Hi everyone, I'm James Peck, Head of Tax within Tech and High Growth at Cooper Powery. I'm joined by Sam Ross from Remote, and today we'll be exploring employers of record in a bit more detail and answering some of the questions that you've all been asking. Over the past few years, we've seen the use of employers of record becoming the go-to model when entities are looking to expand overseas. Given the flexibility and use of working with EORs, it's quite obvious why so many companies are choosing this approach to scale their international profile so rapidly. Companies are using the model to scale at pace into new countries, to stand up decentralized teams or allow UK staff to work remotely, or using EORs as the main conduit to exploit growth. Sam and myself will shine some of the light on the areas that are potentially leaving businesses open to the unnecessary tax risks, and that's what Sam and myself will discuss today. Sam, over to you for a quick intro.
Hi everybody, as James said, I'm General Counsel at Remote, and I specialise in building and growing legal teams in high growth tech companies. And before that, I worked at Barclays, and before that I was an M&A lawyer. But the last 2 years at Remote, I've been non-stop consumed with how we can best support our clients that are growing internationally. And as James mentioned, employer of record is one of the services that Remote provides.
Perfect. Sam, is it worth us just kind of starting at a very high level and just going, I'm sure that most people on the who are watching this today understand what an EOR relationship is, but for those that aren't familiar with it, is it worth just exploring that quickly?
Absolutely. So there's some confusion also between a PEO and an employer of record as well, particularly in the US. So an employer of record is basically what it says on the tin. We employ people that you find somebody who you want to work for you. Let's say, for argument's sake, they're based in Bulgaria. You may have traditionally engaged this person as a contractor because you wouldn't necessarily know how to employ somebody in Bulgaria. You wouldn't know how the tax system works there. You wouldn't know necessarily how to employ somebody compliantly there. So you might just have sent them a generic contractor agreement. The employer of record model enables you to give that person their full local Bulgarian employment rights under a compliant Bulgarian employment contract via Remote's or another EOR's local entity. We will give them that employment contract. We will make sure that the correct taxes are withheld. We'll make sure that they have really, really good benefits that are very competitive in their local market. And then for all intents and purposes, they're working with you on a day-to-day basis, and you pay us or other employers of record a small service fee for us to take care of that for you.
So, Sam, you've already touched on one of the areas where there could potentially be tax issues associated with hiring individuals overseas. And just being completely clear, I think this is one of the areas where EORs have really kind of squared that away. There aren't any issues in relation to operating payroll in country for those relevant individuals. Where we've seen uncertainty over the last, say, 6 or 12 months, and that where questions are being asked specifically by our client base, is in relation to when an EOR is creating, or the hiring of individuals through an EOR is creating what we're referring to as a taxable presence, a permanent establishment in any given country. And again, I think this is the one area where there is uncertainty in relation to how do you create a taxable presence, when that is triggered, and what the obligations are as a result of that. So previously, this was defined as either a fixed place of business, an agency PE, or a service PE. However, the definition and the commentary to the model conventions have been adjusted by the OECD in 2016 and impacting since 2017. So let's look at each of those different ways of creating a taxable presence, a PE in turn. So fixed place of business, the first way, is where there's a level of permanence in a country. And that's generally, for the purposes of tech companies, related to either an office location or a shared office space. So actually, a WeWork office location can create a taxable presence within a country. Now, there is no general rule of thumb about how long this should take, but you can kind of gauge it somewhere between as little as 3 months or as long as 6 months. in terms of creating a kind of taxable presence in that jurisdiction. Other ways of doing it is also creating kind of manufacturing plants or factories. They can also create fixed places of business. Not so relevant for a tech company necessarily, though. The second way is if you've got an agency PE. So previously, an individual was determined to create an agency PE if they were substantially negotiating, concluding contracts on behalf of a principal company. However, the changes to the rules now have tightened the definition of an agency PE. So if that individual plays the principal role that leads to the conclusion of the contract for the transfer of either property, services or rights belonging to the principal enterprise, that will create an agency PE within that country. We also need to be cautious about the changes of definition of an independent agent. The definition of that have tightened in the last few years, and therefore one needs to consider that in more detail. There are exemptions that can apply to permanent establishment. So if an individual is determined to either be determining either proprietary or auxiliary services, then actually that might not necessarily create a permanent establishment in country. If services are too distinct or remote from the core business activity, then they will not be considered to create a PE. But again, you need to look at that on a case-by-case basis and determine to what extent, if any, you are creating a PE in country. There have been changes in relation to the rules. A new introduction was by virtue of what we refer to as the anti-fragmentation rules that were applied to stop companies splitting cohesive operational businesses into several smaller operations. Again, this was a way of previously separating how a PE could be created in country. Now what's needed to look at, you need to look at the aggregation of those across our country in totality. The third way that a PE can be created is a service PE. It's not an OECD principle, but it has been adopted by the United Nations Model Treaty Principles. Where we're looking at is countries such as Malaysia, Indonesia, and the Philippines. In these countries, the provision of services either internally or externally can create a taxable presence, and therefore due care and attention is needed and considered in more detail. So once you determine that there is a permanent establishment within a country, a couple of things that need to be considered. So first and foremost, to what extent do you have a filing obligation in that country? So do you need to make a declaration in that country to the relevant tax authorities? So actually, you need to make a decision in terms of, do you have or should you have a branch in that country? Should you think about setting up a separate and legal entity in that country? So some form of subsidiary. And therefore, to what extent have you got a historical exposure in relation to the entity, and how far back do you need to go back? I.e., do you need to go to the tax authorities and say, look, we've been acting in this country for X amount of time, and as such, there may be tax liabilities in order to kind of pay historical payment of those taxes. In terms of determining what relevant tax needs to be thought through, that needs to be calculated in terms of actually undertaking an exercise. And now that will depend on the activity that's been undertaken. That will be very different if you've got a fixed place of business versus an agency PE. And again, we'll need to look at, on a case-by-case basis, what activities have been undertaken and how to price those accordingly, and therefore what consideration needs to be given there.
So obviously an employer of record has got a pretty tough job in ensuring compliance with employment laws in however many countries that they're operating in. So you need to do your homework to make sure that that employer of record is actually keeping track of all the evolving swathe of employment law changes that there are. Things like collective bargaining agreements, things like minimum salary changes in certain countries, things like pension laws, things like remote working laws. Really, really important that your EOR is investing sufficient resources in making sure that they are keeping up to date. Otherwise, there's no point, frankly, having an employer of record. The next thing is to ensure that any intellectual property that your person is creating is properly transferred to your company. This is a major issue when it comes to due diligence rounds and exit, because if you've hired someone via an employee of record and you can't trace that chain of IP transfer from the employee to your company, that's going to present a huge red flag to any potential investor on a DD round. And of course, you just need to make sure that's the case anyway. So the good thing is that under operation of law and typically in employment contracts, the IP will vest in the employee of record. Then you just need to make sure that that IP transfers properly across to you as the client. So definitely do your homework on that. And then finally, one of the biggest risks that we see out there is cybersecurity and data protection risk. It's important to note that the employee of record is going to have access to a huge amount of your employees' information. That can include things like health records and other types of very, very sensitive information. So again, really, really good idea to do your homework and make sure that the employee of record has put in place really good data protection frameworks and security practices to make sure that your employees' data, the employees' information is kept safe. So I've talked through what I consider to be the main risks, and Remote's invested considerably in tracking and tracing employment law risks as they emerge. We've got an internal system that we call the Watchtower, a database of employment laws that is constantly being populated. And then we have associated change management processes that take place to ensure that as soon as we're aware of the change, that change feeds down to our operations departments and clients are informed about what this change means for their employees. And then the employees are obviously informed as well. Then in terms of data protection, we're building as very, very robust data protection framework. We invested heavily in this area, and we're doing things like getting external security validations to make sure that objectively our security is best in class. And then just also as part of the process of coming on board to Remote, we will talk to you about your specific issues and risks. Even the PE one, the permanent established one that you referred to, we'll take the time to talk through your specific circumstances, whether it's to do with tax issues like you were talking about, or potentially misclassification of contractors. And we've got teams of people who will actually invest time talking through those issues with you so that you can be confident that whatever solution you choose, whether it's employer of record or one of the other services we offer, like global payroll, if you decide to set up your own entity, that is the right service for you, rather than just trying to flog you something without properly considering what your needs are. Yeah, so this is a big misconception in the market, that an employee of record can't help you with equity, and you can't use an employee of record if you're awarding equity to your staff. It probably just means that the employee of record hasn't really thought about it and doesn't really want to deal with it. But in certain countries, there's not really a choice. If you're employing somebody, and then let's say you're employing somebody in the UK and they are awarded equity, you have obligations as an employer. So Remote UK has various obligations in relation to the employee of record people that we hire. We have to file a return. In certain circumstances, we have to withhold tax when people exercise options. So we've done the work to analyze that in all the countries that we operate in, so that when you, as a client, grant equity to your people through your plan, it's your plan, you're granting the equity, but Remote will administer anything that it needs to administer as the employer. And in some countries, there are withholding obligations on a taxable event. In some countries, there aren't. But our job as the employer of record is to talk through those issues with you, the client, and make you comfortable with how granting equity works in respect of all these countries that you're operating in. And we will sort of walk you through that and ensure that everything's really, really clear. And so, yeah, definitely you can reward people with equity if going through an EOR. So the key thing when it comes to the key risk when it comes to IP transfer is ensuring that the local law has been properly followed and understood, which is why we start by going to local counsel in the markets where the employees are based. So ensuring that the documentation reflects the correct legal position in that country to ensure that all the IP is properly transferred to Remote.
Yeah.
And then once we've done that, it's a bit more of a straightforward exercise to ensure that the IP then transfers onto the client. You can, if you know, there's an alternative to that. You can have a direct IP assignment between the employee and the client. The downside to that is that you're not necessarily going to have the local law provisions in there. Let's say you're a US based company and you're getting a direct IP transfer with a US clause in there. You wouldn't necessarily be able to cater for the local law considerations if the employee is based in France, for example. So there's a few correct ways of doing this, but remote's way we've had, you know, externally verified by a whole heap of lawyers that they're very, very comfortable with how it works.
Great. Thank you, Sam. Thank you so much for covering some of those kind of key topics today. If anyone's got any further questions, they want to fire across to either Sam or myself. But thank you so much. Bye now.
Thanks, bye.